Let's take it up with our legal panel. Mercedes Colwin is a criminal defense attorney and a Fox News legal analyst. Also joining us, Anahita Sedaghatfar, a criminal defense attorney as well, joining us from California. Welcome to both of you.
Thanks, John. Great to be here.
Anahita, let's start with the end of this case. You don't think there will be a conviction. Why?
I don't think so, John, because I think the castle doctrine in Montana is extremely broad. In fact, it's broader than a lot of the stand your ground laws we have in other states. And the law clearly says that you can use deadly force to protect your home if you're in fear of imminent bodily injury or if you feel that a felony is about to be taking place in your home. And in this case, we know the defendant was burglarized twice before this incident. And he says when he saw this random intruder entering his property in the middle of the night that he was fearful. He feared for his life. He feared for the life of his family, and that's why he shot and killed the victim. And if that's true, then the jurors have to acquit him because that's justifiable self-defense in Montana.
Mercedes, do you agree?
Well, certainly that's certainly what the law is, but it's interesting.
There had been 2 previous burglaries, Anahita, in this guy's garage, and he said, you know, I was nervous, I was scared. That's why I installed the surveillance system that alerted me to the fact that I had an intruder in my garage.
Absolutely. And I don't think the prosecution's argument that he somehow lured this child into his home for the sole purpose of shooting and killing him, I don't think that's going to carry any weight. And I think ultimately, like you said, it's going to come down to the reasonableness of the defendant's conduct at the time of the shooting and whether or not those jurors believe that he reasonably feared imminent bodily injury or if he feared that he was going to be burglarized once again. And the defense does have evidence of these burglaries. They've identified the burglars in those 2 prior instances. And so even if the jurors don't buy that he feared for his life or he feared for his safety because the victim was unarmed, I think it's totally reasonable for them to believe that the defendant thought he's going to be burglarized once again.
John, but you know
I think that's
really
a compelling argument.
Too? The key is that the homicide happened in the garage. If you really believe that your family...
Right, I was just going to say, according to Mercedes, that's why this law is very controversial, and the jurors are going to be instructed that this defendant didn't have a duty to retreat or to call the police or take other measures before he shot and killed him. So I think if those jurors follow the law, follow the instructions, I think there's going to be an acquittal in this case.
All right, Anahita Sedaghatfar, Mercedes Colwin, good discussion. Thank you both.
Thank you.
Thank you.